Hi, I'm Sotelo with SBEMP Attorneys. Welcome to part 3 of our series on changes in employment policy due to the COVID-19 pandemic. Before we get started, I'd like to welcome our esteemed panel speakers. First, Judge Harold Hopp, the Norma Castaneda HR Advantage founder, Josh Bonner, CEO of the Greater Coachella Valley Chamber of Commerce, and finally, Andy Cloutier, Director of Human Resources at the Greater Palm Springs Convention and Visitors Bureau. First, we'll start with Norma. Norma, many of your clients are typical of the businesses that we have here in the Valley. They are small to mid-sized employers. How are these laws coming out of COVID, particularly the Families First Coronavirus Response Act? How are these small to mid-sized employers able to comply with these laws, and if they're having any difficulties, what are those?
Yes, well, with FFCRA, there's a bit of confusion with some employers, and sometimes it's the way I explain it to our small employers is break it up into the two provisions, right? One is the sick leave that you are to provide your employees, and the second part is the extended family medical leave in case their children's childcare is closed. So if employers could just remember those two provisions, it makes it a lot easier to break that down. Number one, with the paid sick leave, it is the employer's responsibility. Now I'm speaking of employers under 500 to extend paid sick leave to their employees that are full-time for at least 80 hours. Now it also applies to part-time employees at a reduced rate. The second part of it is, what do I do with my employee that, the child care closes or the nanny has suddenly fallen sick? That too has its protection. So employers have to allow their employees to take that time off, and it is paid. Now, the second part of this is, of course, when they're caring for their children, they are paid at 2/3 of their full-time rate. And again, for part-time employees, there is a different calculation for that. A lot of employers have a question as to what happens if my employee called in today and has a positive coronavirus test. Well, at that time, they qualify for FFCRA, for the paid sick leave, and they must be able to allow the employees to quarantine. Now, in some specific, in the provision, it does say that small employers under 50 can apply for an exemption, although, I would recommend, of course, for legal advice if the employer was to opt for that.
In terms of providing the paid leave, are any of your employers reporting that compliance is imposing an undue hardship upon them?
Yes, obviously, with small employers, it's hard, right? Because of cash flow, it's, their business is already suffering due to loss of business. And how do I pay this being a small employer? There is credits. There's a tax credit that is available for small employers that they qualify for. What we do for our employers is we try to work with their payroll service so that we can code their employees to a different section so it's easily tracked, and then they can apply for these tax credits.
What about verification for leave? Under the FFCRA, are the requirements the same or are they different?
They are different in terms of when we have employers that are paying for the tests for some of their employees, because obviously it is important for them to have their workforce. When it's paid, you can sign for a release that releases that information to your employer, which would then qualify them either to get the paid sick time off or, they return to work.
And as you mentioned earlier, there are tax credits that employers can apply for, correct?
There are tax credits, and it just takes for you to talk to your CPA or your accountant to figure out how you get these tax credits. And obviously, a lot of employers, because of cash flow issues right now, for example, restaurants, are really suffering. So how do I get that back quickly? And from what we can see, employers are getting their tax credits as long as they have good record keeping.
Exactly. Unlike the paid sick leave law that we have here in California, you're going to have to ask your employees for verifications in order to get the tax credit. What about the new supplemental paid sick leave requirement? I know it affects only those companies that have 500 employees or more nationwide. We don't have many of those companies here in the desert, but have you heard anything with that?
We actually do not, personally with our clients, we have not gone through that yet. So not sure how that is affecting the larger employers.
Okay.
Yeah.
I'd like to briefly summarize the supplemental paid sick leave law that the California legislature just enacted into law a few weeks ago. Everyone is familiar with the Families First Coronavirus Response Act. There were exceptions to that act. Certain healthcare workers, employers of healthcare workers, were not required to comply with that act, nor were large employers defined as those companies that have 500 employees or more. So the supplemental paid sick leave law fills in that gap that the California legislature identified. In other words, those companies that previously did not have to provide paid sick leave for coronavirus-related reasons now must do so. Employees are now entitled to 80 hours of paid sick leave if they were not given those sick leave benefits prior, or they were exempt from it because their employer had too many employees. Now, if an employee is sick with COVID, is required to quarantine because of COVID, is unable to work because of COVID because his employer required everybody to stay home to mitigate the spread of COVID in the first place, then that employee would now be entitled to 80 hours of paid sick leave to the extent that he did not receive it before. I'd like to move now to Josh Bonner of the Greater Coachella Valley Chamber of Commerce. Josh, you have members that fall into this category of those employers that previously did not have to comply with the FFCRA. Have you heard any grumblings from your members about this?
We do have some that fall under that category. A lot of times we think of employee thresholds as being physically present, but a lot of times what happens is we have satellite offices that are operating as part of larger regional operations. There's a lot of those warehouse operations, construction, pipe and supply, right? A lot of those different types of companies that are satellite offices. It tends to not be as big of a deal for those folks simply because the larger companies generally have access to human resource departments and legal and advice resources that they can tap into that sort of keep them in line. It tends to not be big of an issue as it does for some of the laws, which I know we'll be talking about, that tend to impact the smaller employees. That's where we hear a lot of it.
All right. Moving on to what's impacting local businesses. Some of you may have heard that California has just revamped some workers' compensation requirements so that now there's a legal presumption that if a worker has to leave home to go to work and he contracts coronavirus, the presumption is that he contracted COVID at work.
Sure, and this has been quite a topic with employers, and how do I do this? How do I respond? I mean, basically, employers just need to know that if you have an employee who has tested positive, it is a recordable incident on your workers' comp. So it's very important that employers know that within 3 days, that's 3 days, they have to report that to their workers' comp. At that time, each individual insurer will get back to the employers with any information that they need. But if the employers could just remember, the reporting period is what is important.
To give background on this issue, we know that if we get hurt at work or injured at work, we receive workers' compensation benefits to address those injuries. Previously, one had to prove that you were injured at work. Now, with the new law that was just recently passed, if you leave home to go to work and you contract coronavirus, the workers' compensation presumption in California is that you contracted the coronavirus at work. Judge Hopp, can you explain to us what a rebuttable presumption is?
Well, I'll try. A rebuttable presumption is one that starts out with, absent any other evidence, this is true. But you can offer evidence to rebut it or change the presumption and show that the presumption isn't correct in this particular case. So, for example, here, you'd start out with a presumption that the employee was exposed or contracted the COVID on the job or doing work-related things. But if the employer could show that the exposure actually happened at home, say kids came home, a spouse was infected before the employee was infected, for example, then you could show that the presumption doesn't apply here, or it's been rebutted.
So that's exactly it. For those of you who are wondering, what does it mean that there's a rebuttable presumption that the injury or the COVID was contracted at work? It means just that the case starts with a belief that it happened at work, and then it's up to the employer, to the extent the employer wants to dispute it, to present evidence that the employee did not contract it at work. So for example, if the employer can provide evidence that it had an effective COVID mitigation plan in place, that the employee actually made statements about having contracted it at a family gathering or going on vacation, or any other evidence that would normally be admissible to show that this was not a work-related injury. So it sort of works backwards. You start with a belief that the COVID was contracted at work, and then it's up to the employer to provide evidence that it did not. Thank you, Judge Hopp. Norma, with the new workers' compensation rebuttable presumption in place, are you hearing from your clients that they are seeing increased workers' compensation filings?
Yes, quite significantly, actually. And, that's always the question. How do I know if this really happened at work? Or how do I know if employees are not, gathering with families and so forth? But it's very clear when you read through through workers' comp and what the expectation is. The onus is on the employer, right, to prove that it was outside of work, and it's very hard to do that, especially when you see an outbreak in a certain department. We've had some clients where there has been a positive coronavirus test on one of our employees, and then all of a sudden, the rest of the department is now showing some signs, and then before you know it, it's a whole department. And this is why it's so important to take these testing seriously and, not take the risk of having an employee come to work just simply because, you do need that manpower. It's more important that you protect your workforce so that you don't have a pandemic within your own business.
Have you had any issues with your employers reporting if this has had any adverse effect on the workplace? Does it affect morale at all?
Absolutely. And it also, it's a scary feeling, right? To know that some of your coworkers have possibly been around you the last couple of weeks. It's very untelling if they have been contracted, and all of a sudden as HR, we try to bring a level of calmness to the workforce so that there is not, people that panic. Right. But yes, it definitely affects morale around the company. But I think that the employers that have been most successful, our clients are, they're provided with a checklist of what happens. And I think that when an employer takes active steps and be proactive about what we do if there's a coronavirus, in our workforce, what are the steps that we take? And I think that makes employees comfortable. My company has a plan. I know that they're doing the best to take care of us. And I think that brings a calmness within the workforce if you're prepared and you have a plan.
I agree that employers have to have a written plan that would help to address these situations. I know employers are required to have a thorough reopening plan. Have employers been able to come up with these plans, and what kind of help do they need from HR professionals?
Well, I think it goes back to, the plan that each employer chooses to take, right? I think our most successful employers are the ones that have checklists on an everyday basis where they are taking the temperatures of their employees. And one particular client who is very responsible and has a larger workforce, they have over 50 employees, they have a complete wellness check that they take every day at the start of work. And it's a checklist, and it's, taking their temperature. How do you feel? Have you had any of these symptoms? And that has proved to be very effective. And their COVID tests, they actually go as far as paying for their COVID-19 tests. We actually have a service, and we have a provider that works with all of our clients. And our client, this particular client, he sends 10 people just to send them out to see, check the temperature of their workforce. And luckily they had one department where they did have a positive coronavirus test, but after watching it and so forth, it hasn't spread. So I think that with these reopening plans, if you take all the steps that are necessary, although tedious and sometimes a bit costly, these employers are saving cost by being a little more cautious.
Absolutely. And just to remind our employers, Cal OSHA defines an outbreak as follows. If a company has 100 employees or less, 4 confirmed cases of COVID or 4% of your employees qualifies as an outbreak under Cal OSHA regulations.
That's an important point that you make, because that's a couple of our employers that are very small, that have only 10 to 15 employees. You can imagine what that 4% looks like, right? That can really make an effect on their business.
If I could just add to that, I think there was just in the last couple of days an emergency order issued by the health department that if an employee may have been exposed at work, the employer has to pay for the COVID-19 test.
That's absolutely right, Judge Harold. It's so hard to stay on top of the pandemic with things changing every day. Thank you for bringing that up, Judge Harold. So Josh, are you hearing from your members about employers having any difficulties implementing a written COVID policy?
No, I think a lot of employers, especially the larger employers, are probably ahead of the curve on that. I think where the challenge really was early on in the outbreak and in the weeks and months that followed. It's interesting, we were talking about comparing to normal workplace injury. You cannot catch a virus transmission on a camera, right? And so you try to be as proactive as you can with your policies and procedures. But a lot of that early on was starting to run head on into California privacy laws as well. Right? If my employee says I got a positive test, do I ask him to show it to me? Can I require them to go get a test? Confusion around, does an antigen test count, or does it need to be a regular test? And so I actually think as time has gone on, the state and the health department has sort of tightened up those things, probably to the benefit of employers, so that we know exactly what's expected of us. But there was quite a bit of confusion, especially in the early stages of the pandemic.
I think we're seeing all these new laws passed in California. It's the end of the year. We have new laws. We have laws coming out of COVID. We have laws from the first wave of COVID that are now being supplemented.
V, could I add one more thing to that? The laws that have been added or orders that have been made don't supersede an employer's obligation under the ADA or FEMLA, right? Employees still have those rights. Employers still have obligations under older laws that to some degree conflict with or overlap the obligations under the more specific newer laws.
That's correct. That's a very important point. Employers are consumed with COVID. However, there are still substantial laws in California that they have to comply with in spite of COVID, such as the ADA and HIPAA. Thank you, Judge Harold. Now I'd like to move to Andy Cloutier. Andy, please tell us what an employer can do to keep up that collaborative spirit now that all their workers are working remotely and separately.
Thank you for having me today, V. In HR, we talk a lot about communication. Even under normal circumstances, we are always talking about communication. That's how you build teams. That's how you engage your employees. And now we have a situation where, we might have a handful of people working in the office. We have most of our employees working from home, and we have another group of employees who are on furlough, who aren't working really at all at this point. So how do you communicate with those folks and keep them engaged in your work? You can't just walk across the hall like you used to be able to do and have a conversation with someone. So really, we're doing Zoom today, but I think what I'm seeing a lot of is a lot of emails going back and forth. And I get a little frustrated by emails because emails are great for transactional sort of issues, like what time is the meeting on Friday? Who's going to be there? Those sorts of things. But they really aren't great about, you know, kind of fostering that engagement between employees. And so if you weren't doing it already, you know, employers really need to pick up the phone. You need to pick up the phone and interact with people. You need to schedule Zoom meetings if those make sense. I think we're all a little zoomed out at this point, but it's really the only way you get to see people's reactions to things. And so having those sort of interactions, I think, is really important. I've been guilty about sending out too many emails. I send out inspirational emails to my staff to try and inspire them. Sometimes they're fun, sometimes they're kind of more culture, you know, related to our cores and culture. But I just think it's really important that whenever possible, instead of engaging in that, you know, that email chain where you're going back and forth with each other, you got to pick up the phone. You got to talk to each other, because not only are you going to be able to talk to that employee about the business and the task and job duties, but you're going to be able to ask that employee, hey, how are you doing? What's going on? Is there something you need from me that'll make it easier for you during this time? Those sorts of interactions, employees really appreciate hearing that. And it gives them the opportunity to actually ask you questions, because they're kind of out there and maybe there's this, you know, black hole of information, and, you know, employees sometimes go down a very dark hole. And sometimes it's really important to be able to kind of get them back on track and let them know what's happening and provide that sort of engagement with each other.
I think that is so important. I think so many employers lose sight of the fact that employees are working remotely. I think you're the one who pointed out to me, Andy, that we need to remind them they are still a really important part of our workforce, regardless of the fact that they're not physically in the building. That being said, it's important to have policies to regulate employee conduct while they are working remotely.
Well, you know, it really is setting those expectations for employees. It's important for people to know what you expect. You know, so for example, if you're a 9 to 5 sort of business and you expect your employees to be available 9 to 5, you need to make sure that they know that. There's so much uncertainty right now. If you're not telling people, then how are they supposed to know these sorts of things?
Right.
Some of our jobs at the CVB are very much, you know, 9 to 5 sort of jobs, whereas others where they're, you know, the hours are a little more flexible. So it's important to understand that not everyone is the same, you know, and you need to treat people like people and individuals. You know that your accounting team is going to be a lot different than your marketing team on a lot of different things. And so it's hard to have just one policy that relates to everyone. You do want to be fair and equitable, but you have to understand that there are different jobs and different ways of going about their business. And it's important to recognize. And you touched on something really important before, is like, you don't want to treat your employees like robots. They're not robots, they're people. They have families, they have concerns. You know, I've had so many conversations with employees who are going through, you know, difficult times right now, whether they're financial issues, health issues, those sorts of things. And it's important, you know, to listen and hear those employees, and kind of like we talked about before, you need to be flexible on things. Just because you have a policy that says one thing doesn't mean you can't deviate it. These are extraordinary times right now. And we can't be so locked into, well, this is what the policy says. Prior to COVID, we really didn't allow employees to work from home. Right. We had very few employees working from home, and suddenly, pretty much around, you know, March 14th, suddenly we flipped a switch, and, you know, more than half of our employees are now working from home. So you have to be able to, you know, kind of be flexible and work with your employees.
I agree, Andy. Flexibility is key. Let's talk about independent contractors and AB5. Both have been on the minds of California employers lately.
Well, you know, I think AB5 really created a new challenge for employers. So many employers were very reliant on those independent contractors. And, you know, for years in HR, we've been kind of asking for more guidance on how to differentiate between employees and independent contractors. And sometimes you have to be careful what you ask for. Because now we have that guidance. And, And really, there's a presumption now that if someone works for you, they're an employee. And so unless they meet the criteria of the ABC test or fall under one of the exemptions from that, it's a challenge for people because there are many organizations that have to look at how they're doing business and take a look at the risk that they are running of misclassifying someone as an independent contractor.
To give our audience some background on AB5, that law essentially reduces the elements that an employer would use to determine whether workers are independent contractors or employees. Previously, employers in California were used to analyzing that status using an 8-prong test, which is more comprehensive and allows the courts, the jury, the EDD to look at 8 different factors to determine how to properly classify a working relationship. AB5 essentially gutted that 8-prong test and reduced it to 3 prongs, making it very much more difficult for employers to meet the 3-prong test in order to properly classify workers as independent contractors. Andy, have you seen any employers challenge AB5?
I haven't seen any real evidence of that from the CBB. It's one of those things where you don't really know you've misclassified someone until someone calls you on it, and you end up talking to V or in a courthouse, and they tell you you've misclassified someone. And so I think most employers want to do the right thing. They want to classify people correctly, but it's difficult. There are, you mentioned different jobs. For example, there are about 50 plus exemptions from AB5.
Yes.
And some of those fall under those kind of journalists, creative types, those sorts of folks. And even then, if I remember correctly, there was a limit on how many articles, a writer could write for you, or how many stories they could provide, and what constituted those sorts of issues. And so it was really interesting to see, from a marketing and creative standpoint, how that would work out. What if you had a band that performed in your restaurant? Are those, are they independent contractors or are they not? And you look at those, you look at the ABC test, and sometimes it's easy and sometimes it's not, to really make that distinction. And so I think you have to have those conversations. Hopefully you have someone like V who's fantastic about bouncing ideas off of, that you can kind of come to a consensus where you feel comfortable. But, there are a number of things that employers should be doing if they haven't done it already. If you don't have written contracts with your independent contractors, that's just a terrible thing. You need to have a written contract. Those contractors should have business licenses.
Absolutely.
They should have insurance. They should have hopefully a tax ID number that's not their social security number. A couple of other issues that I always like to bring up when I talk to folks about this. You should never have an employee who received a W-2 and a 1099. So if you have an employee who's receiving both a W-2 and a 1099, you have a potential red flag there from an IRS standpoint. I remember a number of years ago, I worked for a large media company known as the Mouse House. And we had to go through and review all of those. There was an issue with that. So we did that. It was painful at times. The other thing you have to be really careful with independent contractors is you have an employee who's doing pretty much the same work or substantially the same work as your independent contractor. Once again, another big red flag for people. That means you've misclassified someone. And if the presumption is everyone who works for you is an employee, you've just misclassified that independent contractor. And you could be on the hook for taxes, overtime, wages, benefits, bonus, stock options. There's so many different things you could be on the hook for if you misclassify someone. It really is critical that people look at those things.
That's so true. The ramification of misclassifying someone today is so much worse. Now, the independent contractor can sue you for unpaid benefits, lost wages, statutory benefits, stock options, back pay, everything. So what we're seeing is industry groups with strong lobbies in Sacramento are able to get carve-outs for their industries. For example, pharmacists, physical therapists, the motor club, franchisees, franchisors. They're able to get carve-outs from AB5. But what we're talking about, though, is not an automatic designation that they get to be independent contractors. Rather, what we're talking about is that their relationships are tested pursuant to the 8-prong test that is easier to satisfy than the new 3-prong test codified in AB5. Judge Hopp, in the past, when an independent contractor case appeared before the court, the test that the court used was the 8-prong test, not the 3-prong test.
When the Supreme Court decided the Dynamix case, and I'm going to mispronounce it too, that really was a big paradigm shift, and told lower courts, you're going to follow a whole bunch of different rules now. And in some ways, as you mentioned, it's a lot simpler. It's not as many factors. It's in a lot of situations a lot easier to apply, but it's also much more likely to result in someone being found to be an employee. I would note one thing that there's been some confusion about. Proposition 22 did not reverse AB5 except as it applied to a couple of specific industries. Most employers, if they were employers and not contractors, are still going to be governed by AB5.
Right.
That's absolutely correct. The thought was that with the passing of Prop 22, the industries can take their foot off the gas and not worry about AB5. But Prop 22 is limited to just the gig drivers, the Uber drivers, and the Lyft drivers. Norma, are you seeing employers struggle with AB5?
Not so much so as a few years ago. I think that most employers are taking an active approach. And to be honest with you, I think some of them even, just basically want to put everybody in as an employee just to not have that issue come up later. And, it has been a good practice for a lot of employers, but I have to agree with Andy. We have a lot of private golf clubs, for example, that, they have people that it might work as a 1099 during the summer because they're seasonal, and then W-2 during the high season. And although that makes a little bit of sense because they don't have schedules and so forth during the summer, it's still an employee. And, you can't miss, it puts you in a difficult position. And you do have audits that will come up. If you have an employee that both has a 1099 and a W-2, I have seen probably 90% of those employers, they do get an audit. And then it's pretty messy after that because they go back several years and you're paying taxes and all of the things that come with it along with the penalties. So, I don't see as much of it anymore, but it's an issue with some of the seasonal employers.
That's correct, Norma. I've seen that too with seasonal employees. Josh, from your perspective, dealing with members of the Chamber of Commerce, are you seeing a lot of issues with AB5?
So AB5, probably along the same lines as Norma, it probably hasn't been a huge deal. I did want to comment, though, just on the trajectory of AB5, because you talked about some of the carve-outs and different things that were happening. Of course, our chamber, like a lot of chambers, strongly opposed AB5. Commerce and capitalism moves very fast. Our government and law moves very slow. I knew that would bring a smile to Judge's face. And so, when you look at AB5, I think what you're seeing is a law that comes from probably a different paradigm than what's actually happening in the commercial environment now. And so what's happening is you're starting to see these carve-outs. Prop 22 was narrow in focus, but it was a carve-out all the same, where they're sort of having to retrench and say, this probably doesn't fit for the reality on the ground right now. And quite frankly, as commerce continues to evolve and commercial activity continues to change in the way it's being conducted, I rather suspect that AB5 will probably die a death by many paper cuts. It's just, it'll get chipped away at because of the way we do business now is so much different than how it was done 15, 20 years ago. So AB5 is really a sort of a fascinating case study from a Chamber of Commerce perspective, simply because we think that the government got it wrong in this case, and we think time will bear that out.
That's a good point, Josh. I think the million paper cuts can't come soon enough for California employers. Josh, in your role as the CEO of the Chamber of Commerce, what are you hearing at the state legislature?
Yeah, so Sacramento obviously is very progressive in how they're protecting employees and how they're dealing with labor law, proudly so. In fact, a lot of the other states look to California. A lot of our laws will end up becoming laws in other places. There's a few areas, I think, as a chamber where we have some concern. We're seeing more, and I always tell people with Sacramento, if you want to know what's going on, don't pay attention to what passes. Pay attention to what barely fails, because those bills inevitably will come back up in future sessions. We're seeing a couple of trends. One is there's more and more sort of uncontrolled law within the workplace. Things that you cannot necessarily control as a employer, but will impact you. I'll give you a great example of that. AB 628 this year, the BONTA bill, it didn't pass. It barely didn't pass, but that would have given time off to an employee who had a family member that suffered sexual harassment. So you're talking about a situation where something is completely out of your control. It didn't even happen in your workplace. And we're seeing more and more bills like that that are extremely employee friendly, not just to what happens within their workplace, but what may happen in other places. The other trend that we're seeing is, when some of these laws were originally enacted, FLA and some of the other ones, there were pretty significant carve-outs for smaller employers. And I think wisely so, because government recognized that, listen, the rules for a very large corporation that employs 2,000 people probably isn't going to work for a mom and pop that's employing 3. But what the state of California has been very aggressive about and continues to be is those laws keep working their way down into smaller and smaller areas. There was a paid family leave trailer bill that was tacked on to the budget this year that would have given all kinds of extra leave time for employers as small as 1 employee. And so that's the other trend we're seeing. And then the other issue, of course, is just the disparity in legal resources available to larger corporations versus smaller businesses. Larger corporations, I cut my teeth in big corporations before I came to work for the chamber. If I had a question, I walked upstairs to HR, told them the question, I got my answer. It doesn't work that way in a small business. In a small business, you are either relying on legal advice, and of course the clock starts the ticking as soon as you make the phone call or shoot the email, or even worse, you're relying on the internet. And for all of the things that come to our attention about the following of rules, the truth is these rules are broken thousands of times every day, not out of intentional negligence, but out of folks that simply don't have the resources to go through and get all the facts. And so they're making the best guess that they can. And that's when we start to see our businesses get into a lot of legal jeopardy, and we have a lot of concern for them. So I could go on about Sacramento for a long time, but those are some of briefly, those are some of the trends we've been seeing relative to employment law out of the State House of late.
As for your members' response to the law, particularly the smaller employers, are you aware of any alternatives or resources that they might have for legal or HR assistance? Sure. So the Chamber tries to be a front line for that. When the law came out about harassment prevention training, we worked with some local attorneys to offer it free of charge to get that out to them as a resource. The labor law posters, I call them labor law wallpaper now because there's the size of a wall. But, just simple things like that to try to get them some resources. There's also some legal hotlines. Cal Chamber, for instance, has a legal resource for members. They can call up and get advice. You can, if you're a member of a local chamber, they can call Cal Chamber and try to get some answers as well. Our local labor attorneys are fantastic. I could go on about the amount of free time that they put in trying to help our local businesses be compliant.
they truly would rather you do it right than them have to defend you later. I can tell you every labor attorney's ever told me that, and they really do mean it. So there are a lot of resources out there, but listen, the great thief of small business and business owners is time. You can give the resources, but for the gal or the guy that's trying to operate their business on their own and they have very limited time, that temptation to just do the best I can or to just Google it as opposed to picking up the phone and calling a qualified attorney or trying to seek out these resources. Sometimes that's a barter that they make to their detriment, unfortunately. And that's, we see that a lot, I'm sure, as attorneys and involved in law, you see that as well quite a bit.
So coming up next year, we're going to see an increase in minimum wage again. So Andy, when we spoke about this, you immediately pointed out that this is going to affect employers' classification of exempt employees. Can you explain that?
Absolutely. The difference between an exempt and a non-exempt position sometimes can be a little difficult for people to ascertain. But one of the basic tenets of it is to be an exempt employee in California, you have to earn twice minimum wage. So come January, when minimum wage, I'll just use $14 an hour, increases to $14, your minimum wage is $28 an hour, which equates to about $56,000 a year. So if you have employees, regardless of what their job duties are, who are making less than $56,000 a year, they are non-exempt, or you will have to adjust their salary.
And that's a great point, Andy. So often employers forget when they see an increase in minimum wage, they just think about their hourly employees. They forget to consider what effect that has on their salaried employees. As of January 1st, 2021, most employers in California will now have to provide 12 weeks of job-protected leave under the CFRA, the California Family Rights Act. Norma, are you seeing any issues with that?
Yes, absolutely. That is a big concern for our small employers. And, it being in HR, I think, Andy, you can attest to this, it's very difficult to find an employee to just pop in, right, for that time to fill in the gaps and let alone the training that goes behind it. I mean, you can't get an employee to full speed until maybe after 90 days with a training. So it really puts the employers at a disadvantage, especially our small employers that are just trying to get through everything else they're getting through right now with coronavirus. So it is a challenge. Some of my employers have said, it would be very difficult for me to comply for that. I'm taking the risk, just they just don't know what to do with it. But I think, unfortunately, what I hear from a few of the small business owners is they're just going to take the risk.
These expansions that we're seeing now, making things difficult for employers to comply, we may see some employers just taking a calculated risk to not comply and then defend their decisions later. Josh, in terms of the Chamber of Commerce, are you seeing your members requesting assistance in order to comply with AB 1383?
Yeah, so we've tried to get the information out to them as best we can so that they understand it. I did have a comment too on the conversation that was just taking place, because the other thing that I'm finding, and this is very troublesome for the chamber, a lot of businesses are simply choosing not to grow. So if you're a family-run business and there's just 2 or 3, I just talked to a business like this last week where they potentially could expand and they could add jobs. But when you start looking at the risk involved with expanding your employee workforce, especially if you're expanding it outside of a family operation where there's maybe a higher level of trust, wisely or unwisely, that's a calculation that you have to look at. And so, when you start talking about laws that are directly inhibiting job growth, that's very concerning. And there are businesses out there that they do the cost benefit factor, and they simply come to the conclusion that, it's not worth it for us to expand and grow. We're going to stay exactly where we are. And so I think that that's another one of the troubling trends that we may see come from 1383 and other laws like it.
And I recently read that California's ongoing efforts to heavily regulate the workplace has had an adverse correlation to economic growth, and that is troubling.
And V, just to add to that, I've had a couple of, I work with a lot of entrepreneurs and that have very successful businesses. And, I talked to one business owner and, he was talking about maybe building a second company, to kind of get him under that 25 and so forth. And I think it's important for employers to know that there's still a controlled group. And I mean, you're the expert, V. You could probably, shed light on that. But, that doesn't work either. And I know that a lot of employers are trying, to do DBAs or they form another company. But when it's all under the same controlled group, you're not getting away from those limitations.
And Norma, I don't know if employers realize this, but the legislature has figured it out. If you have the same control group, it doesn't matter that you set up 8 different subsidiaries. It's going to be viewed as a single employer.
Yeah, quickly, I did want to add one thing to that. We don't see it as much inside of our area because we have a hyper-local economy with tourism, ag, a lot of things that are tied directly to our location. But when and my friend Joe Wallace at CVEP talks about this a lot, when you hear about businesses leaving the state, that is a real problem. It is not contrived, it is not made up. And so that is, when we start talking about these conversations of how do mid and larger companies react to these laws, that is one of the adverse reactions, though, that we're starting to see accelerate, particularly amongst a lot of the faster growing economies along the coast is, California competes for businesses like everyone else. And as these laws continue to become tighter and tighter in nature, we are seeing some of the businesses migrate out of the state. I wanted to add that as part of the conversation because that is becoming a real problem.
And that's not anything that anyone in California wants to see. Are you seeing any response in Sacramento to this?
Not yet. Again, you have to understand the nature of the State House. I'm there quite a bit every year. It is the loudest voice in the room right now. Tends to be labor unions, environmental and social justice groups. And so the movement of the State House is very much geared in that direction. I think it's safe to say that business probably has had a diminished voice over the last few years. And that's for better or worse. I suppose it depends on what your perspective is. But, I think right now the State House continues to move in the direction of being tighter restrictions for environmental controls, for employee rights and protections. And when you're competing with states like Texas, Arizona, Nevada even, that maybe don't have these rules as tight as what we have, it's not that difficult for a business to move. And let me just say, it's becoming even more easier for a business to move now that we're working remotely. I think it makes these businesses even more nimble and able to move themselves around.
As we were preparing for this webinar, Judge Hopp made the comments that California has a tendency to enact laws without thinking through the compliance aspect. If we go all the way back to the late 1990s, when California's overtime laws and work hour laws and meal and rest period laws were completely being revamped, Judge Hopp, do you recall seeing then whether California employers had difficulties complying with such a huge overhaul of workplace regulations?
Well, I'm not sure if sympathetic is the right word, but when you try to assess how much of a penalty, for example, to impose, you mentioned earlier, or maybe Josh mentioned earlier, that you can get so much, up to so much per employee or violation or whatever. Well, you're naturally not going to impose as much if somebody was trying to comply with the law and just didn't realize the law had changed, and it's early now 20 years later. No, you should know what the law is and you should be complying with it. But if I may, I'd like to follow up on a couple of things that Josh said about Sacramento. This year was a weird year in Sacramento. The legislature was literally physically unable to meet for a significant period of time. The governor issued and the executive branch issued a number of emergency orders. There was a little bit of pushback from the legislature. I suspect there's going to be more pushback from the legislature in the new year. But again, we don't know if they're going to be able to physically meet. That may be a problem again as caseloads across the state increase dramatically. I suspect they're going to figure that out. I hope we don't have another end of session where literally a new mother has to bring her infant to the floor of the assembly to be able to vote on an important bill, or that we have nearly a dozen senators couldn't come to the floor of the Senate because they had been potentially exposed to COVID. So I hope that the legislature work that out more and they'll be able to meet more consistently. But as Josh said, there's a lot of pent-up demand for legislation that just there wasn't time to consider in this year's session. As one of our former legislators used to joke, in Sacramento, no bad idea ever goes away, obviously, because somebody thinks it's a good idea, right? And so there's a lot of pent-up demand for legislation that they just didn't have time to consider that's going to come back next year. There are also in Sacramento in the coming year going to be some significant budget challenges, ironically different than what we anticipated 5 months ago when they passed the budget last summer, because now it looks like, according to the legislative analysts, we're going to have in the short term more money than what we thought, but in the longer term less money than what we thought. So how the legislature balances that, the kind of tug of war between the legislature and the governor over who gets to set policy is going to be real interesting. And like I say, I hope they're able to physically meet, because they just didn't get to a whole lot of things. The other thing that Josh said that is really an important trend that I got to say, and not that I know anything about writing laws, but that isn't a good long-term trend, and that is the legislature keeps putting more and more significant policy decisions into budget trailer bills. Budget trailer bills almost always get passed because they're part of the budget, right? Everybody who's voting for the budget generally votes for the budget trailer bill. And the problem is that if you stuff a policy idea into a budget trailer bill, it doesn't get analyzed the way it would if you had a committee hearing and you actually got to hear from the people who are going to have to follow this law. And we've seen this in a whole bunch of different areas. So I hope that's a trend that, now, I get that in writing laws, the outcome is important. It's it's not like litigation where we want to follow the rules and you know the decision maker doesn't care about the outcome, and the legislature's decision making seems to be the opposite. The important thing is the outcome, not how you got there. So if you can skip around the budget hearing or the committee hearings and so on and put it in a budget trailer bill that you know is likely to get passed, hey, you got the policy outcome that you wanted. But unfortunately, these things don't get vetted very well. And then the legislature finds itself having to rewrite something that's already a law. Well, there's initiative, or not initiative, there's inertia, that's the word I was looking for, to not changing the law. Hey, let's see how it works out. And so this is going to be an interesting year in Sacramento, and hopefully it won't be quite as disjointed as things were this last year in Sacramento.
And Judge Hopp, what is the court's general attitude when it comes to an employer that appears before the court but is saying, Your Honor, I'm making the informed decision to not comply. I don't have the resources to comply?
Well, a couple different things. First of all, it sort of depends on how it ends up in front of us, right? If you've got a labor union or an employee who brings an action to enforce the labor law provisions that you mentioned earlier, and there's a penalty provision, and I get the sense that an employer just said, you know what, I'm willing to pay whatever and not comply with the law because it's just too much trouble to comply with the law, I would be, in general, more inclined to punish that employer more. In other words, if the cap was $25,000 per violation, I'd be looking more like $25,000 per violation because, I'm sorry, we don't get to choose what laws we're going to obey. And if you make a deliberate choice to violate the law, well, that's not a good thing. I hope that answers your question. I'm not sure what
it does.
But there's also, the other thing to recognize is that sometimes it comes before us not in an enforcement action, a civil action, or something may be brought by the Department of Labor Standards Enforcement or something, but brought as a criminal case. And it is possible for certain violations of the law to be prosecuted criminally. And obviously those kind of punishments are different than the ones you might get that you might get in a civil action.
Thank you all. You all bring such a wealth of experience from all sorts of different perspectives. Judge Hopp, from a jurist perspective, how courts would view employers' attempts to comply or not comply with laws. Josh, from the perspective of businesses in the Valley, large and small. Norma, which brings us a unique perspective from most of the small and mid-sized employers in the Valley. And Andy Cloutier, from your perspective as our industry here in the Valley being primarily tourism and how our employers are dealing with tourism being affected in the Valley. Thank you all for your input. And now I'd like to ask our panelists for any closing remarks.
I'd like to say, and this doesn't relate to labor or employment law, but I'd like to say we have taken a lot of measures to try to keep potential jurors safe and to minimize how many people need to come at one time to the courthouse. However, all of us still have the obligation to show up for jury duty when we're summoned. It's not fair to our society. It's not fair to each of us. If those of us who are called or summoned for jury duty blow it off for whatever reason. So please, we're working really hard to make it a safe place for you to come. We're trying to keep down the number of people that we bring in. But please, if you get that summons, please honor your obligation and show up for jury duty.
Thank you.
A privilege to be on this panel. It became pretty clear to me pretty quick. I'm not the smartest person in the room with these fantastic panelists you've assembled, but it was a joy to work with them. Just a lot of folks ask, what does the Chamber of Commerce do? Amongst the many things that we do, we pay attention to those budget trailer bills and what's being stuck in them when no one else is looking. We do a lot of advocacy work and a lot of legislative analysis at the state house, the county level, the city level, trying to keep an eye on this stuff so that you can go about and do your job and run your business. And we do the best we can. It's challenging sometimes. I envy my friends that maybe run a chamber in Texas, but we do the best we can. And we try to work with the legislation that wants to be employee friendly to try to find a way to blend the two so that it can also not be overly burdensome on the employers as well. And, we fight that fight every year and we're proud to do it.
Josh, thanks so much. Norma?
Thank you for the opportunity to be on this panel with all of you. I think everybody sheds a little bit of light on different areas of things happening around the desert and with our local businesses. At HR Advantage, we are happy that we could provide a lot of these services for small and medium-sized employers of the Valley. We know that you have a business to run, and what we hear from our employers is that it's difficult for them to learn everything that's happening around them with these law changes, and especially how quickly things change with coronavirus and what the expectations are of the employers. We have some fantastic little webinars that we'll be posting on our website as well. So if you have some questions, sometimes that could be an easy to answer your questions. But more or less, thank you so much for today, and learned a lot from all of you as well. And for those local business owners, hang in there. I think you have a lot of great help here in the desert.
Thanks, Norma. And finally, my friend, Andy Cloutier. Andy?
Well, thank you again for having me today. It was a pleasure to participate with some fine panelists. HR is really complicated in California. If you're a small business, I just really highly encourage you to partner with your local chamber. Organizations like HR Advantage are great resources for folks. But there's also our local PIRA and SHRM are great resources for kind of keeping up on all these labor laws that are complicated, frequently don't make any sense at all, but we're all trying to do the right thing, and those are some great resources. So I'm so glad you do seminars like this. I think they're just fantastic for helping people understand better what's going on when it comes to California labor.
On behalf of Palm Springs Life and SBEMP attorneys, thank you for watching.